We'll also be monitoring the chat box, so if it's easier to just type in your question, we can do that too.
All right, so we are recording. Let's get started. So I'm Miranda Brown. I'm the Outreach Coordinator for Kentucky Equal Justice Center. You all are probably familiar with us, but we're a nonprofit advocacy organization here in Lexington, Kentucky, and we also have an office in Louisville. And Leah, you want to go?
Yeah, I'm Leah Engle. I'm the director and an immigration attorney at the Maxwell Street Legal Clinic. We're a program of the Kentucky Equal Justice Center, and we handle exclusively immigration legal services.
Great. And we have been interested in doing trainings like this, but kind of the impetus for putting this one together was that we got some questions from some of you all who are with us today about public charge, and so we felt like it would be helpful to go into a deeper dive, share some information, and have some discussion about it. And it's actually really timely too, because some big news came out last week regarding public charge, so we'll get into that as well. So I think we're ready to go on.
All right, great.
All right, there we go. So basically we'll be addressing what is public charge, where does public charge come up, so how did the public charge test change over the last year, and how should we talk with families about public charge, and what can you do to get involved, you know, when it comes to talking about public charge or trying to influence the policy of public charge, to change it, because we know it affects your clients and maybe your organization. And then of course we'll have some Q&A at the end to answer your all's specific questions.
We are a pretty small group though, so if you have questions as we go along, feel free to chime in.
Thanks, Leah.
Yep.
So what is public charge? The public charge test has been a part of federal immigration law for over 100 years. It was actually signed into the first comprehensive U.S. immigration law in 1882, just 3 months after the Chinese Exclusion Act. So public charge as a policy has, or as a regulation, has a history of being a tool that the United States has used to keep people from entering who were poor or physically or mentally impaired, and has also been used over the centuries to exclude people on racist grounds. It was used in the 1920s to exclude European Jews who were trying to escape the Nazis. So it has this history. And the term public charge refers to a person who is considered likely to become primarily dependent on the government for support. So when making a public charge inadmissibility determination, the U.S. government looks at many factors, and these are called the totality of circumstances.
Great. So when does public charge come up? So public charge, it falls under kind of a broad or a long list of issues that are grounds of inadmissibility, which basically, you know, this can include criminal grounds, it can include health-related grounds, and it includes public charge. It's things that people can do that can make them inadmissible or means they're not going to be admitted to the United States. And so a public charge determination or assessment is made when someone applies to enter the United States. Generally either as an immigrant or a non-immigrant, so either as a lawful permanent resident or on a temporary visa. When they apply to become a lawful permanent resident or obtain their green card, again, whether they're in the United States or outside the United States. And then in a pretty narrow category, if a green card holder, if a lawful permanent resident leaves the United States for more than 180 consecutive days, about 6 months, and then when they re-enter, there can be a new admission, or it's considered a new admission, and so they do a new inadmissibility determination. They make sure that they're still admissible to the United States. So it's a fairly limited set of circumstances where a public charge determination is being made. Next slide, please. So this test doesn't apply to everybody. So even as these inadmissibility determinations are being made, there's a pretty long list and broad categories of people who are not subject to the public charge determination. So public charge inadmissibility primarily affects family-based immigrants. So these are people who are have a U.S. citizen or lawful permanent resident family member who is petitioning for them to come to the United States or to remain in the United States as a lawful permanent resident. So for example, public charge does not apply to lawful permanent residents or green card holders when they are applying for citizenship. There's not an, at that point, there is no determination on whether or not they are admissible to the United States. They've already been admitted. Refugees and asylees are specifically exempt from public charge. VAWA, so that's Violence Against Women, self-petitioners, and that applies to men and women who've been victims of domestic violence at the hands of their U.S. citizen or lawful permanent resident spouse, child, or parent. Survivors of domestic violence, trafficking, or other serious crimes, so if they're applicants or recipients of a U visa or a T visa, they're exempt from the public charge determination. Special immigrant juveniles, so these are children who have been abused, neglected, or abandoned by one or both parents and who are in the care and custody of the state. Certain parolees, so people who are admitted into the United States or paroled into the United States. First, generally, it's humanitarian concerns, Cuban and Haitian entrants. And then there are other, this is by no means an exhaustive list. So there are other people, for example, special immigrant visa holders who are Afghani and Iraqi interpreters and translators who worked with the US military are also exempt from public charge. Next slide, please. So, and those, like when the public charge test comes up, people who are exempt from it, that is in no way, that's not changed by the new regulations that came out. That's something that has been part of the public charge, been part of the inadmissibility determinations, for years. So what we're going to be looking at for most of the rest of the presentation is the new regulation, the new rules that were published in August of last year, and that have been kind of back and forth on what is going on with them. So the rules, the new regulation that expands the definition of public charge was published in August of last year. It was supposed to go into effect in October, but due to several ongoing lawsuits, judges in those cases issued injunctions, basically ordering the administration not to enact the public charge regulation while the litigation was pending. Unfortunately, in January, the Supreme Court overturned those injunctions, and basically that's not the end of the litigation, but what they decided was that the government was able to enact the rule while litigation was pending. So the regulation took effect on February 24th of this year. However, and this was the kind of good news that Miranda alluded to, just last week, the government was again enjoined, so on July 29th, was enjoined from enacting the rule for the duration of the COVID-19 national emergency. So we're not, this is a temporary injunction. Basically what the judge ordered was that while there is a declared national public health emergency due to COVID-19, the administration is ordered to not enact, not use the expanded definition of public charge. They've seen immediate and real harm from immigrants who were not wanting to access services due to help with COVID-19 because of this concern with public charge. So as long as the injunction is in effect, which in the order, it doesn't have a specific end date. It just says while there is a declared national health emergency due to COVID-19, USCIS immigration will apply the prior version of the public charge rule, which means as far as public benefits go, they're really only going to be looking at cash assistance received by the intending immigrant, or long-term care in a facility that's paid for by the government, So any of the newly named benefits, and these are the benefits that I think have really concerned people with the expanded public charge definition, SNAP, Medicaid, housing services, any of those newly named benefits used during the COVID-19 national emergency will not be held against the intending immigrant. Next slide, please. All right, so what I'd like to do now is kind of just go through how the public charge policy has changed. This is primarily comparing, I think it might be a little bit clunky at times because we haven't had a lot of time to adapt our presentation with the changing of the injunction. So we'll primarily be comparing, you know, what the old regulation was with what the new regulation was, but please remember that the new regulation is now not in effect again. Next slide, please. Okay, so the previous definition of public charge, which is now the definition we are operating under again for temporarily, is an immigrant who is likely to become primarily dependent on the government for subsistence. So they really, with the prior definition of public charge, as far as public benefits go, they really only looked at cash assistance received by the intending immigrant, and if somebody was likely to be in a long-term care facility at government expense. The February 24th definition, which is what we were operating under until July 29th, was a person who receives or is likely to receive one or more public benefits for more than 12 months, or one or more public benefits for more than 12 months in the aggregate within any 36-month period, such that receipt of 2 benefits in 1 month counts as two months. So if somebody was receiving SNAP and Medicaid for 6 months, that would count as 12 months of benefits. Next slide, please. Okay, so how does the public, that's a good question. So a cash benefit, there's a question, what is the definition of a cash benefit? When I say cash benefit, it's primarily referring to SSI, so supplemental security income, and TANF, so temporary assistance for needy families. So generally it is cash assistance received from the federal government. So how does the public charge test work? So public charge inadmissibility is assessed prospectively. So immigration officials are looking at a number of factors, and they take into account what's called the totality of the circumstances. So they want to project whether a person will become a public charge in the future. Because generally speaking, most people who are applying for their green card, for a temporary work visa, for a temporary visa where we're doing this inadmissibility determination, they would not have been eligible for public benefits anyway. They likely would not have received any public benefits anyway. So it's not necessarily something looking back on have you received benefits, it's looking forward on are you likely to receive benefits. So particularly with the expanded definition, they're looking at the immigrant's age, health, family status, income and financial status, education and skills, and then what's called the affidavit of support. So the affidavit of support is a contract that's signed with the government by the intending immigrant sponsor. So this is either the petitioner who is applying for them to come to the United States, or if the petitioner doesn't make enough money, it's a joint sponsor. So it's somebody else who is saying to the government that I will support this person when they come to the United States if they are not able to support themselves. And so prior to the expanded definition of public charge, the affidavit of support has always been a requirement. And generally speaking, as long as you had an affidavit of support filed by either your petitioner, your sponsor, or a joint sponsor who made over 125% of the federal poverty guidelines, you would not be deemed a public charge. So the affidavit of support kind of took care of the entire public charge thing because you had the sponsor saying, yes, I will support this person, signing a contract with the government saying, I will support this person. with the expanded definition, with all of these new factors, it's no longer dispositive, and it's now just one factor that the government is going to be looking at. Next slide, please. Okay. So yeah, just to review again, and we're not going to go through in depth all of them, but there are different factors that the government's looking at: the age of the immigrant, their health, family status, income and financial status, education and skills, and the affidavit of support. So, you know, with age or health, if somebody is older, or if somebody has certain health issues, then it'll be a negative factor. The government will consider it more likely that will make them a public charge. So we talk a lot about public benefits within the public charge realm, but there really are a number of factors that they're looking at. Next slide, please. So for us at Maxwell Street, because we only work with low-income immigrants, income, even before the expanded definition of public charge, was always one of the biggest issues for our clients with a family petition, because we did need to have somebody we did need to have that affidavit of support showing that the sponsor made over 125% of the federal poverty guidelines. So in a very real way, the expanded definition and even public charge in general has always imposed an income test on our immigrants. So it allows the government to consider the income of the people in the household, the assets that they have in cash or savings, if they've ever applied for a fee waiver on any of their immigration applications, any public benefits that they've received or applied for, their credit history and credit score, their enrollment in private insurance, or resources to pay for reasonably foreseeable medical costs. So within all of these considerations for income, there's a few heavily weighted positive factors or negative factors. So if the immigrant, if their household or if their joint sponsor has income of over 250% of the federal poverty guidelines, that is considered a heavily weighted positive factor. Whereas if the family's income is below 125% of the federal poverty guidelines, that's considered a negative factor. So it really, in many ways, like they say, they're looking at a list, or it is the totality of the circumstances. They're looking at a number of different things, but it really does come down to imposing an income test and imposing limitations on the number of poor immigrants that can be allowed into the United States. Next slide, please. Okay, so just to review some of the heavily weighted factors. So some of the heavily weighted positive factors, there really aren't a lot of them. As private unsubsidized health insurance, that can be a positively weighted, heavily weighted positive factor. If they have income or assets or support of at least 250% of the federal poverty guidelines, as I said, that's also a heavily weighted positive factor. Heavily weighted negative factors are if the intending immigrant has a lack of a job or job prospects, which can be pretty hard if we're talking about people who aren't in the United States, to have a job lined up before they're coming. If they have a health condition without private insurance or the ability to pay, or the money to pay for care, and if the intending immigrant has received public benefits, that can also be a heavily weighted negative factor. But again, many people are not eligible for benefits prior to being lawful permanent residents.
Leah, you appear to be frozen.
Miranda, can you hear me? Am I frozen?
Now I can hear you.
Okay. Where did I lose you?
It sounded like you completed the information on this slide. You were talking about receipt of public benefits being part of the totality of circumstances test, but I didn't hear anything after that.
Okay, I think all I said was next slide, please.
I figured.
Okay, so then what are the benefits that we're looking at, that we're talking about within the public charge regulation? So the long-standing policy, and the policy that we are again back in this land today, is cash assistance for income maintenance. So some temporary, like more temporary or state-run or local cash assistance isn't what we're looking at. We're looking at supplemental security income, federal cash assistance for income maintenance, and then long-term institutional care at government expense. And so these are still considered under the new policy. That's not a change, but within the February 24th policy, within the new regulations, we're also looking at supplemental nutrition assistance, so SNAP or food stamps, federal, state, local, and tribal cash assistance. So whereas prior to this, we were only looking at federal, looking at supplemental security income or long-term cash assistance, the new regulation does include all forms of cash assistance. Housing assistance, so public housing, Section 8, housing vouchers and rental assistance, and then Medicaid, but there are still some exceptions within Medicaid within the February 24th policy. So there are exceptions for emergency Medicaid, for coverage of children under the age of 21, pregnant women, new mothers, and then the testing, prevention, or treatment of COVID-19 was included as an exception even prior to the injunction. But again, we're back in the long-standing policy world. So from July 29th until the end of the public health emergency, the national public health emergency, we'll again only be looking at cash assistance for income maintenance and long-term institutional care. Next slide, please. Okay. And so these changes are not retroactive. It is a prospective policy. So the use of any newly named benefits before February 24th of 2020 are not considered in public charge determinations. And the use of any of these newly named benefits between July 29th of 2020 and whenever we reach the end of the national health emergency, those benefits, newly named benefits, should not be considered in public charge determinations either. So in any of the regulations and in any of the associated forms, the original effective date of the regulations was October 15th of 2019. So any reference that you see in any of the information on about public charge that says October 15th really should be read as February 24th. Next slide, please.
Okay.
I think it's your turn.
It is. So Leah talked about what public benefits are included in the new regulation, except some types of Medicaid. So basically any benefit not specifically listed in the new regulation will not be considered in a public charge determination. And I know there's a lot of questions around, well, what benefits are, you know, it's hard, you don't want to look at what's included and then say something's not included without some reassurance maybe. So here's a list of some examples of public benefits that are not considered in a public charge determination. So benefits received by an immigrant's family member, benefits received by a person while in an exempt status, like some of the statuses that Leah mentioned earlier, like a refugee or asylee, for instance. Emergency medical assistance, so that could include emergency Medicaid as well. Medicaid for children under age 21 or for pregnant women, including 60 days postpartum. As Leah mentioned, Medicaid for testing, prevention, or treatment of COVID-19 has specifically been said that it will not be counted. Disaster relief, entirely state, local, or tribal programs other than cash assistance. The Children's Health Insurance Program, which is CHIP, KEJC in Kentucky. subsidies under the Affordable Care Act, so the tax credits to be able to afford plans on the marketplace, Head Start programs, WIC, the Supplemental Nutrition for Women, Infants, and Children, school breakfast and lunch programs, pandemic EBT, which is the food benefits while kids are out of school, energy assistance or LIHEAP, transportation vouchers for non-cash transportation services, non-cash TANF benefits, and TANF in Kentucky is the KTAP, Kentucky Transitional Assistance Program, federal earned income tax credit or child tax credit, and the stimulus payments under the CARES Act, veteran-specific benefits, student loans, and foster care and adoption. So these are some examples of programs that you shouldn't have to worry about. They are not considered in a public charge determination with or without a national health emergency. Did you have a question, Jennifer? Yeah, there you go.
I can't raise my blue hand. I don't know where it went. So sorry. So all of these things aren't considered at all when looking. Okay, that's good news, because this is what a lot of the people that I work with, these are the type of benefits that they use. So I was thinking all along that they were included. So thank you for making that distinction.
Yeah, absolutely. That's the point. Great. Okay. So how does the rule affect the use of housing and homeless assistance programs specifically? A lot of you on this call are involved in these programs. So the new public charge rule explicitly includes only 3 federal housing programs. That's Section 8 Housing Choice Voucher Program, project-based Section 8 rental assistance, and public housing. So the final rule does not include any homeless assistance programs. And so the changes under the new rule, what is the impact of them? Obviously, there are some directly affected individuals, but as Leah said, few people who are subject to the public charge test actually qualify for the benefit programs that are covered by the regulation. The regulation's expanded criteria that totality of circumstances, covering age and income, credit score, health, and those other factors, that expanded criteria is likely to harm more people than the added public benefits are likely to affect. And then, of course, while few people may be directly affected by the new public charge rule, we're obviously very concerned about the broader population of people in immigrant families and mixed status families who are just at risk of this chilling effect, that they've heard about this and they may not fully understand it, and so they're just afraid of enrolling in any public benefit, and so they may not enroll in benefits that they really badly need, especially right now during the pandemic. So we're really worried about this chilling effect affecting many more people than would otherwise be affected, and obviously it's a very complex regulation to understand. And then the third bullet point here is providers and community. So obviously you guys have been affected by this regulation in that you're trying to understand it, you're trying to help your clients understand it. People may not be coming to you who otherwise would because they're afraid of being a public charge. And then it's obviously more complex for you to understand the impact of your services for these people. And it has an effect on communities as well, because if people aren't getting the services that they need, then they're in a more vulnerable state, especially during the pandemic when they could really badly need medical care, for instance, or housing assistance. So how do we talk about public charge with folks in our community, with our clients?
Miranda, we had a question. We had a question on whether presumptive eligibility Medicaid is considered under public charge now.
Good question. So presumptive eligibility Medicaid is considered like regular Medicaid, basically, because it's not considered an emergency Medicaid. So in any case, when regular Medicaid would be counted, so would presumptive eligibility. However, as of the new injunction that came out last week, any benefits considered under the new regulation that are used during the declared national health emergency would not be counted in a public charge determination. So presumptive eligibility Medicaid is something Kentucky is using to cover more people during the emergency. So as long as the national health emergency is considered in effect, and we don't know when it will be ended, there's no expiration date on it. But as long as that's in effect, presumptive eligibility should not be considered. Okay, any other questions before I move on? All right, so how do we talk about public charge to our clients, to other service providers, to people in the community? We have a picture here of Marilyn at a DACA rally saying, "No hate, no fear. Immigrants and dreamers are welcome here." And that's part of the point when we talk about public charge. We don't want to be just scaring immigrants from enrolling in benefits that they need. So our top line messages are the Supreme Court's ruling that Leah mentioned earlier allows the public charge regulation to take effect while litigation proceeds. However, we had to update this slide as of last week. The regulation, the new regulation for public charge has been halted during the declared national health emergency. So as we've been saying, use of these newly included public benefits during the national health emergency for COVID do not count in public charge. Second message here, fear is President Trump's real weapon here in these new policies. Like we said, with the chilling effect, it affects a lot more people just because of that than it does actually. And so helping immigrant families understand the facts is going to be their real defense in getting what they need and protecting their families. And then third point, the fight to protect the right of all families to thrive isn't over. Like Leah said, there's ongoing litigation, newer litigations caused the injunction last week. People are fighting this on all fronts because we know that families need benefits. All right, Leah?
So when you are talking to families, to individuals about public benefits, about things that they might qualify for, might be eligible for, when is it okay to enroll them in these programs, and when do you maybe need to refer them to an immigration attorney to talk to somebody or to talk about the public charge implications? So, if you're talking to someone and if their family members are already U.S. citizens, great, they should continue to enroll in any programs that they're eligible for. If they already have green cards, so if the client, if their family members already have green cards, that shouldn't have any impact. They should be, continue to enroll in any programs they're eligible for. The one kind of caveat with that is if they are a green card holder and plan to leave the country for more than 6 months, it is a good idea to talk with an immigration attorney. But that's kind of true in general, whether or not they're looking at applying for public benefits. And so if they're already applying for or have, one of these statuses, so if they have TPS, if they have a U or a T visa, if they have asylum or refugee status or special immigrant juvenile status, then they would be exempt from that public charge eligibility, and they should go forward and continue to enroll in programs. It's also, and I'm not sure we qualified this, but it is important to note that the public charge determination really looks at receipt of public benefits by the intending immigrant. So if you have a family where the parents might be undocumented, but the children are US citizens, the children receiving public benefits is not something that will be held against the parent in the public charge determination. So absolutely, parents should be getting their kids the services, the benefits that they're entitled to. Next slide, please. All right. So the area where people really should be talking to an immigration attorney and getting advice before making any decisions on public benefits is if they are planning to apply for a family-based green card. So for example, even somebody who's in TPS, which is one of the statuses we listed on the last one, because that's a temporary status, if they think they'll apply for a family-based green card in the future, they should talk to an immigration attorney. So, but just as a reminder, like only the use of the programs covered in the regulation will be considered in the public charge test. Their income, age, health, education will also be considered. And then, you know, if they're applying for a family-based green card, they really should talk to an expert for advice on their case before making any decisions. But again, like we're kind of back in green light land for almost everybody at this point where we have the injunction in place. So if they are very concerned, you know, you may still want to refer them to talk to an attorney. But otherwise, you know, the receipt of those benefits right now during the public health emergency is not something that they need to be concerned about. Next slide, please.
So I'll just add here on this slide, that link is for a listing of immigration attorneys in whatever area that people are in. And our Maxwell Street Legal Clinic is on that list, but of course there are other options for people.
Oh, thank you.
So we wanted to share these resources with you all. The Protecting Immigrant Families Campaign has been a partnership between the National Immigration Law Center and the Center for Law and Social Policy. And they have, since the beginning of even rumors about public charge and the beginning of our administration's new rules regarding immigration, they formed this coalition and brought in national and state and local partners, and Kentucky Equal Justice Center is a member of the campaign. So the protectingimmigrantfamilies.org has a wealth of resources about public charge, and they are always updating them constantly. There are resources currently on their Know Your Rights page, flyers like this, one-pager kind of fact sheets like this that you can be sharing with your staff, with your clients, that give really clear information about public charge and who is affected. They haven't got, you know, in such a short time span, they don't have brand new materials covering last week's injunction, but I'm sure that they will be the first to produce those. So we wanted to make sure you know about those resources, and they have, you know, an email list you can sign up for to get regular updates when they do have new news and resources that you can learn from. So we use Protecting Immigrant Families a lot. In fact, many of the slides that we're using were adapted from their shareable materials. So it's a great resource. And, you know, we shared our top line messages, but if you want to share other messages with your clients, these are kind of more on the nose, in-depth messages. So most immigrants who are subject to public charge are not eligible for the benefits counted in the test. And we're kind of just reiterating some of the stuff we've covered, but these are like the top points. So we want to make sure you take away from this and share. Use of public programs does not automatically make you a public charge. Of course, that's because the totality of circumstances covers other things. Use of public programs during the declared national health emergency due to COVID-19 does not make you a public charge. Many public programs are not considered in the public charge test, like that list that I shared. Benefits used by family members will not count in public charge decisions. And there are laws protecting the personal information of public benefits applicants and recipients. And, you know, that's something that is still true. There are laws and policies that protect confidential information that people submit, for instance, on a Medicaid or food stamps application, and that information can't just be sent over to ICE. It's protected information. And a lot of people have fears around that, but it's still policy. So essentially, people should learn their rights, know their rights, and take action if you can. Get the facts, make a plan regarding finding the right information and talking to an immigration attorney or whatever it is. And people should empower themselves with information. So the main takeaways regarding COVID-19 that we wanted to share, or just kind of review, is that while this is a thing, COVID-19, emergency Medicaid specifically is not counted in the public charge test. It may cover COVID-19 testing, evaluation, and treatment. You know, if a provider says that somebody is experiencing an emergency because of COVID-19, then they can get emergency Medicaid, and it will not be counted. So uninsured patients can apply for emergency Medicaid at the hospital, at benefine.ky.gov, which is Kentucky's enrollment website, at their local DCBS office within 3 months of the emergency, and actually application assisters, people like myself and other service providers around Kentucky who help people apply for Medicaid, you know, can actually help people initiate the emergency Medicaid application as well. They always have to have a medical provider statement proving that it's an emergency. However, U.S. Citizenship and Immigration Services specifically announced that they will not consider COVID-19 testing, prevention, or treatment against immigrants in a public charge test. And then, of course, as we've been saying, USCIS will not count in a public charge test any public benefits other than those cash assistance or long-term care used during the declared national health emergency due to COVID-19. So that's just to reiterate the points we've been covering during this presentation that specifically have to do with COVID-19. And the last one is the kicker here, that any benefits under the new regulation will not be considered during the emergency. So it's your turn, Leah.
Yeah, so I'll try to go through these pretty quickly. I know we're running low on time, but just some examples how to respond to questions as you get them. So if somebody comes in and says, I was just granted asylum a few months ago, and now I'm worried that using SNAP is going to stop me from getting a green card. You know, in this case, the public charge test does not apply to asylees. So we would encourage people to stay enrolled in SNAP, to enroll in SNAP if they haven't already, who have asylum status, and it will not affect their green card application. They are specifically exempt in the statute from public charge. And so they should use the benefits that they are eligible for. You know, so if someone comes to you, I'm pregnant and need help, I'm currently enrolled in Medicaid, but I'm afraid it will be used against me. The public charge test will not consider non-emergency Medicaid used by pregnant women up until 60 days after they give birth. So we would encourage people to get the health care that they and their baby need. And currently, while we're in the you know, back in prior public charge land, you know, any of them that Medicaid, that their Medicaid's not counted in the public charge world that we're in again. You know, my friend says public charge will apply to her, and so she disenrolled from SNAP. She said I should too. In a case like that, everyone's situation is different. What may be good advice for one person could be bad advice for another. We'd always encourage people to learn more about their specific situation and speak to an immigration attorney. Yeah, sorry. I'm scared to sign up for WIC. I know that WIC is a public benefit. You know, in this case, they're right. WIC is a public benefit, but is not included in the public charge test, even with the new February 24th regulations. So we would still encourage people to sign up for the programs that they're eligible for. You know, coverage under my Medicaid plan is the only option for health insurance for my children who are 12 and 19. The public charge test does have specific exceptions for children under the age of 21 that use Medicaid. Their kids fall under that exception, so their use of Medicaid will not be considered in their public charge test. My brother is applying for citizenship, but uses Section 8 vouchers. Is he a public charge? Well, in general, we do always encourage people to come to us themselves with questions and not answer questions about family members, but the public charge test does not come up when people apply for U.S. citizenship. So Section 8 housing vouchers are considered for public charge, but because he's applying for citizenship, you know, public charge will not apply. So we know people do have a lot of questions about public charge. We always encourage, we want to make sure service providers are able to answer some of those questions and provide some of that legal information. But we do always caution against providing, legal advice if you're not a licensed attorney or if you're not authorized to practice law. I think that's it for me.
Okay, so we wanted to share this link, which you can see at the bottom of the screen. This is the Kentucky Cabinet for Health and Family Services. They issued a public letter in April of this year regarding public charge, just clarifying who it does and does not affect, what programs it affects. And this was to partly clarify information internally for their staff and for people who help people sign up for Medicaid. But it is also a tool that we and you can use to show our clients, to show them, hey, we're not just telling you this, like this is official. Kentucky has put out this official statement saying that public charge doesn't affect you in this instance. And this is something that Kentucky Equal Justice Center, together with the Kentucky Office of Refugees and Kentucky Refugee Ministries, we helped the state draft this letter using examples from other states because we knew that this was something some of our clients were asking for, that they were like, I don't know, should I apply for these benefits? And we wanted to be able to point them to an official document showing them that yes, you can. So this is something you can access publicly. If you even just go to chfs.ky.gov and search for public charge, I think Leah said this is the first option that comes up. You can actually download and share this. So what can you do if you don't like this policy and want to get involved, or at least want more information? Like I said before, you can join the Protecting Immigrant Families Campaign. Your organization can become a member of the campaign. You can stay up to date on news developments and other threats that impact immigrant families and join the email list. And every Tuesday, the campaign provides kind of the state of play, advocacy opportunities, new resources. And this is the web link that you can go to sign up to be a member and get their emails. You can also just follow Kentucky Equal Justice Center and specifically our Maxwell Street Legal Clinic on our social media pages and sign up for our email list at our website, kyequaljustice.org. And we also wanted to point out, I kind of mentioned this already, that this webinar has partly been made possible with support from the Protecting Immigrant Families Campaign. They support Kentucky Equal Justice Center working on these issues. So finally, I'll leave this up as we wrap up. This is our contact information if you want to reach Leah or any other staff at the Maxwell Street Legal Clinic and refer clients for intake at Maxwell Street. This is their phone number, and Maxwell Street does free and low cost immigration legal help. And then other services that Kentucky Equal Justice Center offers, besides our advocacy work, we do some direct services. So I help people sign up for free health coverage through Medicaid, and I also provide free assistance helping people sign up for marketplace coverage. And then we have a couple other staff who are able to do that as well. And we help people with wage theft situations where they need help claiming the wages that they are owed, whether it's minimum wage or vacation time or just what they were promised and weren't paid. So I also handle the intake of those cases, so you can reach me at that number there. So I think that we have a few minutes left just for questions. And Leah, you're muted.
Muted. I think we did have one in the chat that I missed. Victoria had asked if we can send, I think, in writing about the presumptive eligibility. Do we have something in writing on that?
That's a good question, because that was something Kentucky expanded after that statement was published. And actually, it was not, but in any case, it wasn't included in the statement because the statement was drafted prior. So we do not have something in writing specifically about public charge, or excuse me, about presumptive eligibility, but it's basically just Medicaid. So
that, yeah, the same Medicaid rules would apply, except not right now, because Medicaid doesn't count right now.
Just one thing, it feels like every election is always, and I guess you've been in this for a long road. It's always the afraid of the public charge. This is not it keeps coming every 4 years. It's always the people, politics use, the public charge, and it scares. I mean, it keeps repeating over and over. The only good thing I can tell you for us, because I work with I had the Spanish, the Kentucky Children Health Insurance, the Kentucky, the Spanish hotline. So far in my term, I have only a few cases when I tell the person, you can apply for your children, are U.S. citizens, and you can have Medicaid and can have either food stamps, but they are afraid. I have maybe I can tell you maybe about 3 cases of a family that I told her, and she still says, no, I don't want it because I'm afraid. I want to buy Affordable Care Act. And I say, but you do qualify. And so it's a few families overall through the years. In the beginning, I remember I worked since 2001. In the beginning, it's true. You can have to pretty much tell and walk with them and let them know, you'll be okay. Don't worry. The benefits are for you, U.S. citizen child. It's as long as you don't get benefits for yourself, you should be fine. And I remember contacting to Maryland. Is that Maryland? Daniel. She used to be the director, and she always was at the Maxwell Legal Clinic with the Migrant Network Coalition. And she's the one who I would reach out with questions if there was something that we didn't know, we needed to, it's always good to refer it to an attorney. Either we will refer it to your organization, or I will ask her, I have a special case, what is the issue with this person? All I want to say is a great job that you guys are doing, because I guess you just have to keep educating people. That's all you can do. So
thanks, Victoria. I think that it's always a good idea if somebody's uncertain, to let them know they can call Maxwell Street or another immigration attorney to get some additional guidance from someone they feel like they can trust. And that's also why we help the state produce that letter, so that people can see it on formal state letterhead that this is what it means. But you're right, sometimes people are afraid, and they have to make that choice for themselves and take whatever risk they're comfortable with.
Thank you.
Are there any questions?
So just to be clear, just the last, I think I got it, but I had to ask you, because this is a 1-800 line, and I get calls from all over. So for right now, July 29, because of the pandemic, it's okay for them to do the presumed eligibility. Families that are they can use the benefit. We can help them apply, and they should be okay. But if there's any doubt or anything, we always can refer them to an attorney, or just go ahead and enroll them, because this is the section, because during the pandemic, the declare of emergency, to keep them safety, it's okay for them to enroll them to presumed eligibility, and it will not be considered public charge, right?
Right. While we are under the injunction, and while we're under the declared public health emergency. So if they decide, tomorrow to declare the public health emergency over, we'll be back in a different circumstance. But while we're under a declared national public health emergency, Medicaid, which would include presumptive eligibility Medicaid, is not considered towards the public charge test.
Yeah, thank you so much, because that way we can help make sure help families, rather than, no wanting to help because you are afraid you don't want to get them into something. I did like one time, but I have it, the emergency time limited Medicaid is good for when somebody has a life-threatening condition, and we should use that first. And I always use that first. Emergency time limited Medicaid, I help them families that are pregnant, or they have a dialysis, or any health-threatening conditions. I always use that. But because of the pandemic, sometimes caseworkers are so busy, and I have maybe 1 or 2 cases in which the caseworker said let's do the presumptive eligibility because it will be quick and it will be 3 months rather than every 2 months with the emergency time limit in Medicaid. So now because of what's going on with declared emergency of, then junction, then it will be okay for them to get presumptive eligibility because it does last 3 months rather than 2 months and renew every 2 months with emergency time limit in Medicaid. So I guess presumptive eligibility will be a good safe route for them right now.
Correct. I will clarify that presumptive eligibility currently will last 2 months if you sign up. But Kentucky's been, they've been hesitant to say anything too long term. And so we don't know if people will be able to sign up for another round of presumptive eligibility to complete the year, or if it will just be that 3 months. They aren't looking too far ahead when they're giving us our parameters, our advice about what we can do to enroll people. So right now it's still a temporary fix. It's still a Band-Aid. The presumptive eligibility, we don't know about that being a long-term option for people. Whereas emergency Medicaid, if somebody does qualify for it, like you said, they may be able to renew it. So, and it will endure outside of the national health emergency. Emergency Medicaid will remain an option that doesn't affect public charge. But I do want to open up the floor if anybody else has questions that you'd like to ask.
I have a quick question, and I know we're not quite there yet, but at some point the national medical emergency is going to end. And at that point, first of all, how do we know, obviously we read the news, but legally, how do we know when that is determined? Who has that determination?
That's a good question. So it's not entire, I have not fully read the entire injunction. I've kind of skimmed through it. It's not clear from the injunction which declaration of a national health emergency they're looking at. I believe it was when the president declared a national public health emergency in March. So presumably it would be then if the president or potentially someone at the CDC declares that to be over. It is specifically looking at the national public health emergency declaration. So that is a change that would come from the federal government. It's not like Kentucky's declaration of emergency.
Then the second part to that question, and thank you, that's a very clear answer, is say that the emergency ends in, I don't know, November, and we have a client whose Medicaid is good until December. Do we then encourage them not to use it as of the date it ends, or not?
So that is a hard question to answer. We don't entirely know how the judge is going to roll back their injunction, or how USCIS will roll back the determination of public charge at the end of the declared national emergency. I would say because public benefits are just one small piece of the public charge determination, and because if they have Medicaid, if it's related, particularly if there is any connection to COVID, I would say it's better for them to be getting the treatment and healthcare that they need. Because I would, if they're coming to me as my client afterwards, I'm making an argument saying no, because USCIS, even before the injunction, said any use of these public benefits of Medicaid in particular, due to testing, treatment, due to the COVID-19, doesn't count. So I would say, in that case, they may want to consult an immigration attorney, but I think it's probably better for them to be getting the treatment that they need while they have that Medicaid.
Thank you.
Any other questions?
Right, we're over time already, so I think, if there are no other questions, we'll wrap up, and we will also send out the recording and slides for you all afterwards. And there are some specific tools related to housing benefits that the Protecting Immigrant Families Campaign has put together that I will be sharing with you all as well. All right. Well, thank you all for joining us.
Thank you.
Yeah, thanks for coming.
Thank you.